Okay, good morning everyone, and welcome to the Wednesday morning online seminar with Silver Shemmings Ash. We have a change of presenter today, and we're very lucky to be joined by Richard Silver, who is the senior partner at Silver Shemmings Ash. He'll be sharing his vast expertise and knowledge gained over many years' experience with us. And this morning we're talking about leave site now and don't come back, so termination in all its guises. As usual, if you could use the Q&A panel in your toolbar at the bottom to submit any questions, and Richard will be answering these at the end. And just a quick note to say that we have made a few changes to the slides to include some additional information. So I will update the slides during the presentation. These will be available post-presentation for you to download. So thank you very much all for attending, and without any further ado, I will hand over to Richard. Good morning, Richard.
Thank you, Julie. Good morning all. As Julie has said, my name is Richard Silver. I am the senior partner of Silver Shemmings Ash. As well as being a solicitor and a barrister, my background is in construction. I was a chief surveyor and construction director of construction companies. I'm a chartered surveyor and a chartered builder. I think it's relevant to say from my background, when I first completed my construction degree, I joined a main contractor on a project which was a large sports centre in Cheshunt. We were working, and having thought about it this morning, remembered it was a JCT 1980 that we were working under, which shows you how long ago it was. And on this particular project, we were having some fundamental problems with the builder, the bricklayer. And what had happened was the brickwork to the sports centre hadn't been set out particularly well. There were considerable defects in the works. They were not progressing the works. There was fluctuations with the labour. We had issues with the unions. The problems continued. And the contracts manager at the time terminated. And we ended up in litigation concerning whether or not the termination had been correct. And despite showing unquestionable evidence that the works as undertaken were defective, that there were major problems and flaws in the works, that the labour wasn't being properly allocated to the site, so on and so forth, we still lost. We ended up paying large amount in damages because we had not terminated properly. A very valuable lesson learned. And what I intend to hopefully do this morning is to explain what nature of issues you need to consider when dealing with termination, and to ensure you get it right, and equally where your contract may have been terminated, whether you have a right to damages. So the starting point is that generally people seek to terminate because the other party is in breach. So what is a breach? Well, a breach basically is doing anything that the contract says you shouldn't do, or not doing what you should do under the contract. But it isn't any breach that allows you to terminate. If, for example, you have failed to complete the works by one day, would that be a fundamental breach? Would that be a reason to justify termination? When seeking to determine whether you can terminate, the starting point is you must read and understand the contract. It will be based upon those contract terms read as a whole, which will dictate whether or not you had a right to terminate. Now, when you are seeking to terminate by reason of breach, you can terminate where the term which is said to be breach is fundamental. It is the very basis under which the parties entered into a contract. But the difficulty is if you think about the JCT, it's called the JCD Conditions of Contract. And it is not all of those conditions that allow you to terminate. It is only those that are fundamental. Now, within contracts, from a legal aspect, there are certain terms that are considered as conditions and others that are considered as warranties. A condition is something that is considered to be fundamental to the contract. It is the very basis of which you have entered into the contract. Those that are not fundamental are termed warranties. They are less serious. The courts have recognized that sometimes there may be blurred lines on terms. For example, if you have to complete the works by a date and you finish 1 day late, it's likely that that's a breach of a warranty. It isn't sufficiently serious to warrant bringing the whole contract to an end. But what happens if it's 7 days, 14 days, 2 months, 3 years, 20 years? Sooner or later, the failure to complete by a set date will be a condition. And therefore, a number of terms are called innominate or intermediate terms, which means that they will be initially a warranty, but as they become more serious, they may move from a warranty to a condition. And what we're identifying is the difficulty under the contract quite often to terminate, to determine whether or not the issue is so serious as to enable you to terminate. So what we're looking at is what are the fundamental terms to carry out the works and hence entitle the innocent party to terminate. Quite clearly, in order to carry out the works, the employing party must have sufficient title to enable the contractor to carry out the works. If he doesn't have title, it's impossible to carry out the works, and hence that would be a breach. Equally, where the party has title, he must give the contractor sufficient possession to carry out the works. So a failure to give possession to enable to carry out the works may, in certain circumstances, result in a fundamental breach and a right to terminate. Recognizing this difficulty, contracts provide for extensions of time. They provide, for example, in JCT for deferred possession. So, depending upon the terms included in the contract, may make specific provision for potential breaches by one of the parties and hence prevent termination. Another similar situation is lack of information. Contractor cannot carry the works out if they're not being provided with the information as to what is to be undertaken. That would prevent the works being carried out. It would be a fundamental breach. It would, in certain circumstances, allow the innocent party to terminate. But again, the contract provides for extensions of time for late information. If the employer prevents the contractor from carrying out elements of the work or the works as a whole, this may well represent the breach of a fundamental term. So if a contractor is instructed to no longer carry out the works, they can't do anything. That would be an anticipatory breach. The contractor is unable to carry out the works and would have a right to terminate. But the situation can come and be much more complicated. I've been involved in many projects where the contracts have not gone as well as parties would like. The job is falling behind. One party thinks it's the problem of the contractor or the subcontractor. The other party thinks it's the problem of the employer and or the contractor. Because progress isn't going as well as they would like, one party seeks to supplement the other party's resources. They may equally seek to give the works to others. Unless the contract provides express provision for such actions, it will represent a repudiatory breach. So, for example, we have a contract, the contractor is subcontract the works to, let's just say, a bricklayer. As far as the contractor is concerned, the bricklayer is not progressing with the works as quickly as he would like, and as a consequence, he seeks to supplement their labour. What he's going to do is to bring on additional bricklayers on site, which he will pay. He will then pass them to the bricklayer to oversee, and then seek to charge the bricklayer for the costs so incurred. Unless either A, the contract makes provision for such an action, or B, the bricklayer has agreed to it, such action would be a repudiatory breach. Now, I know a number of you will be only too aware of circumstances where this has happened. And it's clear, there is much case law that says where a party seeks to bring in other resources on site to carry out works that were allocated to another contractor, unless there is provision in the contract or that other contractor agrees, this will represent a repudiatory breach. So if you are looking to the right to supplement labour or take work away and give it to another's, you can only do so if the contract so provides or the other party agrees. Now, some people say, oh, hold on, under the JCT form of contract, for example, it allows me to instruct omissions of works. I've given an element of works to a party, they're not progressing, I therefore simply omit it. Where's the problem? Well, the contract says you can omit. What it doesn't say is you can omit and give to others. The whole idea of omitting the works is because they're not going to be carried out. Where they are required to be carried out, and you are seeking to take it away from the other party and give it to somebody else, unless the contract expressly allows that, you can't do it. By so doing, you are showing that you no longer wish to be bound by the terms of the contract. You have committed a fundamental breach, and the other party would be able to terminate. The only exception that may arise is where such works are covered under a provisional sum. As the work, or as the title indicates, provisional means provisional. It's not saying you have to do it. You don't have a right to do the provisional works. You only have a right if those provisional sums are expended upon the issue of instructions. So the fact that the provisional sum is omitted and the works are not instructed to be undertaken, those works could be undertaken by another party. Obviously, close to all contractors' hearts is payment. And surprisingly, payment is generally not a condition of the contract. It is in fact an intermediate or innominate term. As I indicated earlier, depending upon the circumstances will dictate whether a party will be able to terminate for non-payment. Generally, simply not paying because you don't agree with the amount that is owed is not indicating that you no longer want to be bound by the contract. What it's saying is I don't agree with your assessment. Being perfectly honest, when I used to work for contractors, we never got paid what we asked for. We always got paid slightly less. I was the QS, and every month, whatever I applied for was always, maybe, possibly slightly more than we'd undertaken. The PQS would therefore assess the amount that had been undertaken and always certified a lesser amount. The fact that the employer paid that lesser amount did not indicate that they did not want to be bound by the contract, so there was no breach. Where the employer even pays the certified amount a bit late is not a breach of a condition. If, however, that situation continues month after month after month, it is possible that that may represent a repudiatory breach if it can be shown that the employer no longer wishes to be bound by the contract. Where the employer does not pay an amount at all, which has been certified, depending on how many payments have not been paid and when that situation arose, will dictate whether or not it is a breach of a condition. The more payments that have not been paid, and the nearer to the completion it is, the more likely it will represent a repudiatory breach. Another one which is quite significant is where the contractor basically removes all their resources from site or suspends the works. By so doing, the contractor's not doing what is their fundamental obligation, to carry out and complete the works. So if they're not carrying out and completing their works, they're in breach of what is their fundamental obligation, which will enable the employer to terminate. Recognising this and the concerns with regards to payment, under the Construction Act, all contracts now have a right to suspend. As I'm sure all of you are aware, in order to be able to suspend, the amount that is due must have not been paid by the paying party, and that the final date for such payment has elapsed. Having had the final date for payment elapsed without payment, the contractor is then entitled to issue a 7-day notice of their intention to suspend the works. So there is 4 requirements. A, the final date for payment must have elapsed. B, the employer has not paid. C, the contractor has issued a notice giving 7 days warning. And then D, that the intention, once those 7 days has elapsed, that they will suspend. If they then do suspend after 7 days, the employing or paying party has no right to terminate. But what happens when, for example, the contractor suspends before the 7 days has elapsed, or they failed to issue a notice? Under such circumstances, it is most likely that the contractor has committed a repudiatory breach, entitling the employer to terminate. This is the case even if the payment hasn't been made by the final date for payment. The right to suspend only arises when the 7-day notice has been issued and the 7-day period has elapsed. The next area that causes fundamental problems is failing to proceed with due diligence. Quite often, the reason why a party wishes to terminate is because the other party is not performing. The progress on site is terrible. But most contracts do not provide time as of the essence. In other words, time is not a condition. The reason we can see that quite clearly is because within most contracts, we have provisions for liquidated damages or general damages, and we also have provisions for extensions of time. These provisions show that the original end date may be extended, and indeed that where the contractor does so extend, the right of the employee is not to terminate, but to seek liquidated damages. So just failing to complete by the completion date is not going to give a right to terminate. But what about where the performance of due diligence is not met? By failing to complete the works with due diligence, the contractor is showing that they cannot carry out the works. They're simply unable to do what they're obliged to do under the contract. And as a consequence, it is likely, or it is possible, that the other party can terminate. So what is the position for due diligence? How do you work it out? Well, that's where the difficulty often arises. What you're going to have to look at is what was the original obligation. You will have to look at when were they originally programmed to complete, or what was the original contract duration, and how late are they? If they're very much close to the original completion date and simply not proceeding, or where the original completion date has passed, it is more likely that you will be able to show that they're failing to proceed with due diligence. Where the contract has only just started, it is going to be far more difficult, because the argument is that they can obviously catch up time in the period that has still to elapse. I should also point out that quite often there is simply a completion date in the contract. I'm aware that contractors quite often include within their subcontracts programs. I've also seen in certain employers' contracts obligations for completing certain areas by certain times. This would be particularly the case in projects I've been involved in schools and hospitals and prisons. But quite often there is a conflict between what the contract says as to completion and these phasing requirements. The contract, let's just say, for example, it's the JCT that has one completion date. It says that if the contractor fails to complete by the completion date, we shall charge damages. It then says in the contract, the contractor shall proceed with due diligence to achieve the completion date. It says the employer shall provide information to the contractor to complete by the completion date. Yet there is another provision that says you should carry out the work in phases. And I should add, this is not sectional completion. This is just a bespoke phasing requirement. What you can see is there is a clear conflict between the completion date and the liquidated damages on one hand, and this phasing requirement on the other. How can you say you've got to meet phasing requirements when you've said there's only one completion date? What can you claim for failing to achieve the phasing requirements? We've got liquidated damages stipulated in one place, but nothing stipulated for the phasing. What we have is a conflict, and the phasing requirements will fall away. So when you're seeking to show that the contractor has failed to proceed with due diligence, be careful. Make sure you establish what the contractor's actual obligations as to performance are under the contract, to then establish whether they're in breach of those terms. Another reason that an employer may be entitled to terminate is where the other party fails to remove or repair defective works, and this causes the follow-on activities to be suspended, unable to be carried out. So if you are looking to terminate for poor performance, which includes defective works, the best way about approaching this is to give instructions, 7-day notices, to carry out the defective works. And if within a reasonable period of time the other party has still failed to carry out those works, you may have a right to terminate, depending upon the seriousness of the works that have not been remedied. So what we've dealt with first of all is breach of conditions, a one-off situation that is seen as so fundamental that the other party has a right to terminate. Now, it's my experience that quite often on a contract, it's not so clear-cut. There's been so many failures by the contracting party, but none of them on their own is sufficiently serious, but as all together, well, that's a different situation. And the second reason I'm dealing with to terminate is where, when all these small breaches are added up together, what they actually do is to evince an intention that the contractor is either unwilling or is unable to carry out the works. In other words, the whole amount of breaches, although small in their own right, when amassed together, is sufficiently serious to entitle the innocent party to terminate. So that's situation number 2. The situation number 3 is where one of the party informs the other party that they no longer wish to carry out the works. Quite clearly, what they're saying is they no longer want to be bound by that contract, and as a consequence, they have repudiated. Let's give you an example. Let's say for whatever reason, what has happened is a subcontractor at tender stage for the contractor has submitted a quotation. The contractor has then incorporated the rates tendered by the subcontractor in his own tender, and has subsequently secured the project. The tender submitted by the subcontract is still open for acceptance. Let's say it said it was open for acceptance for 3 months. The 3 months has still not elapsed, and then the contractor simply sends a letter to the subcontractor and says, I accept. We now have a contract. There's been an offer and there's been acceptance. A contract has been formed. What then happens is the subcontract, having received the subcontract, the order, then decides for whatever reason they no longer want to carry out the works. They may say because they've underpriced it. They may say it's because they no longer like that contractor or they don't have the resources. It may be various reasons. But the fact is a contract has been formed. And as a consequence, by saying they no longer wish to carry out those works, they have committed a repudiatory breach. Where it is showing a breach in the future, as in they're not going to carry out the works in the future, it's also referred to as an anticipatory breach. Under those conditions or that situation, the innocent party would be able to terminate. Now, what you will have seen so far is that there is some complexity or some uncertainty as to whether or not a party can terminate. What we're looking at in the past examples I've given is termination under the common law. Common law is case law. And there are endless cases dealing with termination and whether it was rightful or not. Some have gone to one party, some have been decided in the favour of others. And it is a very difficult area of law. To seek to overcome that situation, many construction contracts include express provisions for termination. Some include certain words which try to make certain provisions fundamental. For example, the term of the essence. By saying of the essence, you are indicating that the term is of fundamental importance. And if the other party breaches it, you can terminate. Simple as that. But what the court says, the simple wording in one clause will not be sufficient. You have to read the contract as a whole. And therefore, if you simply stated that a term is of the essence, if other terms indicate that that term is not of the essence, then the other party, the innocent party, will not be able to terminate where the term of the essence is breached. To overcome that problem, what you now have is express provisions for termination. They actually set down a full details of what are the grounds for termination and what is the manner by which the contract or the employment of the contractor or the subcontractor can be terminated. These are contractual rights to termination as opposed to common law rights to terminate. Let's just give some examples. One very common one is in the case of insolvency, be it the contractor or the employer. Where one party has become insolvent, many contracts provide for termination. They also provide for termination in wrongfully suspending the works, failing to proceed with due diligence and other such factors. What they do is they issue or they deal with a notice requirements, quite often the first notice, which is then a warning, and then a secondary notice, which then brings about the termination. What they are doing is trying to create certainty. They are trying to set down A, when a party can terminate, B, how they are to terminate, and C, what is to happen post the termination. By contrast, under the common law, all those three situations are far more difficult to establish, and therefore there is quite often a substantial benefit in seeking to terminate under the contract. But be warned, if you're going to terminate under the contract, you have to follow very closely the provisions for the issue of notices, etc. I should add that quite often, if not more often than not, the contract expressly includes the provision to terminate either under the contract or under the common law. You will see clauses like the parties' all other rights are retained. That is indicating that the common law rights to terminate are retained. So what we've dealt with is the right or the circumstances under which the contract may be determined. So let's go through a situation. Let's say, for example, that the contractor has pulled off site. They haven't issued a suspension notice. They haven't done anything. For whatever reason, progress is simply not happening. We've got major concern about their financial stability. The concern is if we simply bring somebody else on site, have we repudiated? What do we do? So following the breach of contract by one party, where that breach is a fundamental breach, it entitles the innocent party to terminate, they have an option to elect. They have two options. They have an option to elect to accept the repudiation. In other words, to say, we accept you've repudiated and we therefore bring the contract to an end. Or they have the right to affirm, to keep the contract going, notwithstanding the breach. So I'll give you an interesting example. There was a printing company who were employed to produce a number of brochures for a pending boxing match. What happened is prior to the bout, the boxing match, one of the boxers hurt their wrist and was unable to fight. And therefore the promoter advised the printing company that the project was not going to progress, and therefore they did not want the brochures. The problem was in the order, there was no provision for stopping the order. It simply said, you shall provide X amount of brochures by such a date at such a price. So by advising that they no longer wanted the brochures, the boxing promoter had committed a breach and the printers had an option. They had an option either to accept the breach, not print the brochures and seek damages, or they could continue. What they chose to do was to continue. They produced all the brochures and sought their full price and was successful when the promoter would not pay up. So in the case of a repudiation, there needs to be a decision by the innocent party whether to accept the repudiation and bring it to an end, or whether to affirm the contract and to allow it to continue. And there has to be what is called clear and prompt election. In other words, the innocent party must make the decision within a reasonable period of time, and their decision must be clear. We must know what they are doing. In order, however, to make that election, the innocent party must first know the facts that allow him to terminate. He must know what has gone on. He must know it's a breach, and that he must know of his right to choose whether to elect to accept or to affirm the contract. So there's three conditions. He must know of the breach. He must know that he has a right to terminate or to affirm, and then on that information, having made the decision. So far as that decision is concerned, it can be either express or implied. So express easy, the subcontractor has written to the main contractor saying we no longer wish to carry out the works and we're withdrawing all our labour to site without having any good reason to do so, without having issued a 7-day notice. They have therefore committed a repudiatory breach, a fundamental breach. The innocent party can therefore terminate. So they simply write back and say, we note your repudiatory breach, we elect to accept, and the contract is now terminated. Simple, express. Implied is by their actions. They do something that indicates they've elected to accept. A prime example would be to employ others and to bring them on site to carry out the remaining works. So just to repeat, The subcontractor notifies they no longer intend to carry out the works. The contractor is aware and is informed and has a letter to that effect. They then seek to employ others. By their actions, they're showing they no longer want to be bound by the original contract. They've accepted the repudiation, thereby bringing the contract to an end. But what about the situation where the subcontractor, in my example, is failing to proceed, is refusing to carry out works, they're not on site, but the contractor continues to send letters saying, please carry out the works, please return to site, please do this, please do that. Will that be an election to affirm the contract? The answer is no. Simply pressing for performance of the contract, in other words, simply asking the other party to do what they should already be doing, will generally not be treated as an acceptance of the repudiation. What the other party would need to show is that A, the innocent party was aware of the breach, that they knew they had a right to terminate or to affirm the contract, and that by this pressing for the performance, they were choosing between the two. Where they're saying, if you don't carry out the works, we will be left with no option but to terminate, please come back. They're clearly not electing to choose one of the two options available to them. What often happens is nothing. There's silence, there's uncertainty. Well, silence will not constitute either election. It will not be considered as affirming the contract or bringing the contract to an end. There has to be a positive action. However, where there has been an intervening act of a third party, this may result in the position that the innocent party has chosen to make an election, where the innocent third party's rights and entitlements mean that things cannot go back to where they were before. Now, as I say, I've been involved over the years in many disputes concerning termination. And where one party says that the other party has repudiated the contract, thereby leading to termination, what happens in 99% of the times is that the other party says, no, it wasn't me, it was you. You've repudiated the contract and I'm terminating. And both parties are shouting at the other that they've terminated. In such situation, where both parties had a right to terminate, it is the person who had the right first is successful. So provided you can show that the other party committed the repudiatory breach first, then you will have the right to terminate first. It is not the date the party terminate that is relevant. It is the date when a party had the right to terminate that is key. So what happens? Well, whether the party affirms the contract or brings the contract to an end, the innocent party will have a right of damages. As you will no doubt appreciate, depending upon which election may result in different damages, a different assessment of damages. In my boxing promoter's example, the right for damages would have been loss of profit if he had not produced the brochures. But because the brochures had been produced, the innocent party, the printers, had a right for the full cost of the brochures. So depending upon which option the innocent party will take, will dictate the quantum of the damages. But where the contract is terminated, in addition to the right to damages, the innocent party has no longer any obligation with regards to the performance of the works. Now, this could be significant. Let's give you this example. We have a contractor who has decided to terminate because of the breach of the employer. they recognise that had they been forced to carry out the remaining works, they would have lost a fortune because they'd underpriced it. There may even been a right to damages for further delays in the works. Let's say the completion date hadn't yet elapsed. Well, because the contractor has terminated, they no longer have an obligation to carry out any more works. So the employer cannot seek to recover the additional costs for completing the works because there's been no such breach by the contractor. The contractor had no obligation to complete the works because he has terminated, and therefore any costs in completing those outstanding works are lost. So there can be a major benefit to the contractor in terminating because they no longer have a right to carry out or an obligation to carry out that remains outstanding. The rights that each party had acquired prior to termination are, however, retained. Now, there is quite a bit of case law on liquidated damages, but the basic situation is provided the contract is adequately drafted, a party will still be able to recover liquidated damages for late completion up to the date of termination by the contractor, because those rights were acquired prior to the termination. Similarly, possible payments that the contractor was entitled prior to the termination may be able to be recovered where the employer has terminated because of the contractor's repudiation. Provisions for arbitration adjudication are also retained where the contract is terminated. Quite often, where you are, or I'm a panel adjudicator on the RICS and the CIARB, a number of the disputes that come before me concern termination and whether a party is terminated, and I've been appointed as an adjudicator under the adjudication provisions which are retained under that contract. One important point is to differentiate what will happen where there has been a termination under the common law and where there has been a termination under the provisions of the contract. Under the contract, there is provisions that say what actually will happen following the termination. So, for example, under JCT contracts, a number of them provide that there will be no further payment to the contractor until making good of defects certificate has been issued. And that could be 2 to 3 years' time in the future. There is also provision for the using of the contractor's plant that's retained on site and other provisions. These terms that would therefore be applicable following the termination are quite often very much to the benefit of the innocent party. And therefore, the innocent party will be well advised generally to terminate under the contract provisions and not under the common law. What happens under the common law? Well, under the common law, the contracts come to an end. All the provisions in the contract with regards to further works, payment and the like have disappeared. They no longer apply. The contract has been terminated. The termination means there are no longer any such provisions. So what happens? Well, if there are works completed on site, they need to be valued. There needs to be a valuation then. Monies fall due then. So you can see the situation may be very different to what actually happens if the termination is under the contract. Mindful of the benefits to terminate under the contract, I think it is useful to go through some of the provisions that are stated in the contract. One that is commonly put is that termination shall not be unreasonable or vexatious. That term has been dealt with in case law, and what they've said is that it is an ulterior motive to oppress, harass, or annoy. In other words, the termination wasn't because it was to the benefit of the innocent party, but rather because it was to the detriment to the other party. I'm actually doing it to annoy you rather than for my own benefit. That may be the case where there is only days for the works to be completed. The contract expressly provides I can terminate, but there's only 2 days left and you've shown me you're willing to carry out the works. I've decided, no, I'm going to terminate because now I don't have to pay for 2 years. That'll annoy you. So under those circumstances, the termination under the contract may well be wrongfully carried out. And indeed, it is possible that by so wrongfully terminating, you've committed a repudiatory breach which will enable the other party to terminate. Many of the contracts, JCT as an example, it says with regards to termination, without prejudice to any other rights and remedies. What that means is that you also have your common law right to terminate. As far as the notice, you will be aware that within the contract there are the provision of notices. A, there is detailed provisions as to the timing. There is generally a requirement to issue 2 notices with a set period of time between the 2 notices. If you don't allow the period of time to elapse between issuing the first and the second, it is unlikely that you have complied, and indeed you may have committed yourself a repudiatory breach. So ensure that if you're going to issue your second notice, the period of time from the first notice has elapsed. But equally, where you've issued the first notice 2 years ago, it is unlikely you can rely upon that notice to issue your second notice, where you have to go through the issue of 2 notices. The 2 notices have to be seen to be sufficiently joined. And as the longer the period elapses, the less likely that they will be seen as relating to each other. The contracts often set down how the notices are to be issued. You might say by special delivery, by hand, by recorded delivery, by pigeon, whatever it says. Depending upon what it says is how you do it. Follow what the contract says. It also may set down the content of the notices, that the first notice must be a warning, setting down what the other party has done wrong, and the second notice must repeat what that grounds are. If that's what the contract says, that's what you have to do. As I say, one concern is where a party does not follow those provisions properly. As I said in my first example about that job I was on right at the beginning of my career, the simple situation is we hadn't followed the contract. We hadn't issued 2 notices with the period between the 2 notices having elapsed. Yes, we had good grounds to terminate. The contractor, the bricklayer, was not doing what they should be doing. But the simple point is we didn't follow what the contract said. As a consequence, we'd committed a repudiatory breach, and the bricklayer was allowed to accept that repudiation and thereby bring the contract to an end. The last point I want to address is that where you terminate under the common law for a reason that is wrong, but you then become aware of an alternative reason which does justify such termination, you can rely upon this other reason. And as I've said, where such a situation occurs where there is 2 rights to terminate, it is the first one that occurs. So provided you can show that there was a reason to terminate a repudiatory breach by the other party, and that happened first, then you will be successful in terminating. I hope I've covered this area of law, which is a very complicated one, well, but there may well be questions. Julie, are there any questions?
Sorry, Richard, yes, there are indeed some questions. We had some pre-submitted questions and there may well be others that come in shortly. The first question we had was, would a contractor be entitled to compensation if work was suspended as a result of COVID-19? Now, I know we've covered this in lots of different titles over the last couple of months, but if you could just clarify, that would be great.
Okay. The starting point is to explain what COVID-19 is as far as an event. We have in contracts events which entitle a party to either extensions of time and loss and expense. Some of those events are because of the failure of the other party. So, for example, if the employer issues instructions or issues instructions late, they are likely to cause the contractor to incur delay and possibly to incur loss and expense. Who's responsible? It's the employer. No doubts, that's it. It's simple. And it is for that reason that the contract includes express provisions for extensions of time, because without them, time would be rendered at large. So we have events which are the employer's fault. However, there are events which are called neutral events. For example, exceptionally adverse weather conditions, force majeure. These are events that are not the employer's fault. And therefore, the contract doesn't have to include any provisions for extension of time or loss and expense. It's just because, for example, the JCT think it's fair to include them, but we can delete them if we choose to, because it is not the employer's fault. And COVID-19 is exactly the same. It cannot be said to be the employer's fault, and therefore there would be no right to recover any loss because it's not the employer's fault. The only reason you would be entitled to recover your loss is if you could show that the contract expressly provided for the recovery of loss and expense for coronavirus. Now, under JCT, there are various arguments that coronavirus comes under a force majeure argument. But I'm sure the listeners will be aware, force majeure under the JCT does not provide for the recovery of loss and expense. So in answer, unless the contract expressly provides, which I very much doubt, you will not be able to recover costs associated with coronavirus, I'm afraid.
Okay, on that topic, if people are looking at obviously signing contracts, etc. now or tendering now, what clauses should they be looking at in terms of, should there be a second spike of COVID?
Right, well, the very simple thing is I think you need to include a clause expressly providing for the effects of delays by pandemics or coronavirus. Absent express provision, they will have no entitlement. And indeed, it is unlikely that they will be able to run arguments of force majeure because at the time they entered into the contract, they were aware of the potential problem with the spike. So therefore, it is unlikely to be considered force majeure. For it to be force majeure, it's meant to be that neither party was aware of it. Well, they were.
I don't think there's anyone who's unaware of COVID-19 currently anywhere in the world. Okay, well, that's the end of the questions today. So thank you very much. As always, if you have specific issues that you'd like to speak to Richard about, please feel free to drop him an email at richardsilver@silverllp.com. He's happy to answer questions for you. If there's something you didn't want to particularly raise in the open forum this morning. In the meantime, we have John Sharp tomorrow, who will be talking to us about the update of the insurer's response to COVID-19 and our September schedule online seminars that will be released soon. The updated slides for today's presentation will be sent, a link will be sent out with your CPD certificate at some point in the next 24 hours. So thank you everyone for joining. Thank you very much, Richard, for stepping into the breach. And we hope to see you all again soon. Have a great week and stay safe, everybody. Thank you.
Thank you all.